Hello, everybody, and thanks for joining today. I'm Nick Kaufman, and my colleague Jeff Gleason is here, and we're sort of happy to talk to you about today's topic, right? And this is basically the first of three webinars, all sort of covering how to maximize value and reduce risk in physician and similar practices, particularly from a corporate and kind of legal perspective, right? And um, I'm using the term, and the presentation sort of generally uses the term physician kind of loosely, right? These webinars sort of also apply with respect to practices that maybe aren't technically physician practices, right? Things like dentists, orthodontists, and kind of similar practices. So, each of these three webinars are going to sort of cover different topics, right? The first one is going to cover, the one that we're having right now today, will generally cover um, um, choice of entities, succession planning, and private equity concerns. And I guess I'm pausing here because I'm not sure who exactly is coordinating flipping the slides. Because this is, oh, perfect. And here's the sort of slide, outlining the three webinar series, right? And the first one really sort of talks about choice of entity, succession planning, and private equity concerns. And then, we have a second session on September 26th that will cover non-competes, relationships and agreements among equity members, bonus plans, and employment agreements. And then the final session is sort of a totally different session that will talk about, compliance and risk management with respect to sort of labor and employee and generative AI type matters, right? And so we certainly hope that you'll, join us for those other sessions as well. And, we certainly hope that you enjoy, and, please feel free to ask any questions with respect to, this session today, right? And, I should also note at the outset that this and each of the other webinars is sort of general in nature, right? And it's not really intended to be sort of legal advice with respect to any specific circumstances. I should also note that these webinars focus on ways to reduce risk from a corporate and legal perspective, but there are obviously many other ways to sort of reduce risk in, physician type practices. And, Bond, Schoeneck King has a team of attorneys who are able to help with practically any situation that a physician practice or practitioner within a practice could face. And, we'd obviously be happy to help with any specific scenarios. So let's sort of jump right into it, right? Today's webinar will focus on choice of entity, succession planning, and the corporate practice law. And the thought is to do so by thinking about these issues, at least on a loose basis, over the life cycle of a practice, right? So I think we'll first discuss choice of entity and sort of similar considerations in the context of sort of starting um, and and sort of building a practice. Then we will talk, probably next about the corporate practice of medicine, which will often arise in the context of changing ownership or management of an established practice. And then I think we'll talk at the end about succession planning, which can, and maybe in a perfect world should, also be considered at the beginning of the life cycle, but is often not focused on until kind of later on, right? Um, so if we think about sort of, choice of entity and the related kind of front end planning, certainly sort of a valid question is, why is this important, right? And I guess this is the cue to sort of flip to the next slide. Um, and, that's certainly a valid question, right? And it's certainly a valid question when, you know, an individual or sort of a group of individual physicians are sort of thinking about forming a practice and sort of doing it in a more formal manner than just sort of hanging a shingle and kind of operating as solo practitioners. And when that happens, there's obviously a million things to think about, right? And so certainly a valid question becomes why think about corporate structure, choice of entity, and sort of all the things that are sort of inherent in that, right? That just sounds like another headache, really. And the sort of short answer for why it's important is because if it's done correctly, you can help to reduce risk, not eliminate risk, but help to reduce risk. You can minimize taxes that are owed, and you can also have a good foundation with respect to structures that are going to make life a lot easier for people, in the future, right? In terms of succession planning and continuing the business as people come and go, and things of that nature, right? So, certainly on the front end planning, right? If you've got an individual physician or sort of any group of physicians that now are going to sort of form a practice, and we're thinking about legally what's the best thing to do and what's sort of the best way to think about it. Almost every single time, maybe there's a 1 in a million case where this is not the case, but almost every single time, they're going to want to form some sort of entity, and they're going to want to practice through that entity, right? That is pretty much a million times out of a million the case where there's two or more individuals who are trying to do this. It is also likely the case even when there's only a single individual who's going to practice, so, without sort of other individuals, right? So, certainly one of the first things to be thinking about from a legal perspective is sort of what form of entity makes sense, and what form of entity is sort of best suited based on what the physicians are sort of trying to accomplish, right? And the answer to that is not always the same. And it is driven by what the sort of specific physicians are sort of trying to accomplish and what their particular circumstances are. But there are certainly some, general considerations that can be important, right? So when we think about form of entity, in New York State, there are restrictions on forms of entity that can engage in, medicine and other sort of physician type services, right? Dental, orthodontics, all those. And generally speaking, with very limited exceptions that aren't even really sort of worth mentioning, any sort of entity, whether it's a corporation or an LLC, or even a partnership, and that sort of gets into the sort of three types of entities. Generally speaking, that entity has to be owned by individuals, cannot really be owned by other sorts of entities, and they have to be owned by individuals who are licensed to practice whatever the particular physician practice is that the entity is going to practice, right? So, for instance, if it's going to be an entity that's going to practice dentistry or medicine, then all of the individuals need to be licensed dentists in the case of dentistry, or medical doctors in the case of medicine, and they all need to be licensed in the state of New York. Okay, at least to the extent that they're going to practice in New York. Although if they're not, another restriction is that all of the individuals who are going to sort of be the owners have to practice in the actual entity, right? They have to be performing services with respect to the actual entity itself, right? So, the bottom line is that it is pretty restrictive, right? In terms of the sort of particular sort of owners that are sort of allowed to own any sort of entity in New York. And in New York, this has to be done through a professional corporation or a professional limited liability company, or theoretically through a professional limited partnership. But I would note that the professional limited partnership is so rarely used nowadays that we're really not even going to cover it in this webinar, because essentially nobody sort of ever picks it, and there's really sort of no reason to kind of ever pick it. Really, in instances in which a professional limited liability partnership might make sense, a professional limited liability company is, practically speaking, in every instance, a better choice. And we can kind of talk about why. So when we talk about the New York restrictions on the form of entity, for one, it's got to be a professional corporation or professional LLC. And in terms of the type of entity, we're talking about a corporation or an LLC, right? And when we're talking about forming a professional corporation or professional LLC, that takes a bit more effort than if you were going to form an entity that's not providing any sort of professional service, right? So if you were going to form just a for-profit entity that was going to not provide a professional service, you could have that entity formed and up and running within a couple of days, right? Unfortunately, it's not that easy with respect to a professional corporation or a professional LLC, because at least with respect to any sort of physician practice, there's a requirement to obtain consent from the New York State Department of Education, and specifically the New York State Office of the Professions within the Department of Education. And that requires essentially sort of submitting a filing to them and then waiting for their approval and then getting it back before you can sort of legally form the entity. And that is a process, takes time, typically takes sort of a number of months. And so, forming any sort of new professional corporation or professional LLC that's going to provide physician services takes time, and sometimes changes with respect to that will take time. And that's really kind of almost all the more reason to try and do it right the first time, right? So that you can avoid any sort of delay by needing to kind of do things over or sort of do things again, right? So I think we've talked about the type of entity, we've talked about the sort of practical restrictions. Now, what you would typically think about is sort of what are the sort of general considerations, right? And those considerations, there are a lot of different considerations, but I think the sort of heart of the considerations really sort of go to this list that I have here, right? In terms of who will own it and how many different owners will there be, and what is the intent with respect to the ownership structure going forward, right? If it's, for instance, two brothers who are going to practice as physicians, and the intent is that they're going to kind of go into business together and they will be the only two owners of this entity for the foreseeable future, which could be 20, 30, 40 years. That's sort of a lot different than, a couple of different doctors who intend to sort of form this entity together and sort of practice together for a period of time. But the thought process is that they're going to come and go, right? And so the ownership structure in 10 years could be completely different than what the ownership structure is on day one, right? And that can help drive what makes sense in terms of how you think about forming the entity, right? Also, sort of who will participate, and again, really sort of participate in the management of the entity, and the management structure with respect to a corporation versus a limited liability company is sort of very different. And we'll sort of talk about that. Well, I suppose I skipped down to who will manage it. We talk about who will participate. I think what we're talking about here is the extent to which the entity will have others who are not owners who will also be doing things with respect to that practice, and what does that look like? And are they other licensed individuals, or is it really just sort of the management sort of backdoor services sort of thing? The next thing, which I put pretty far down the list, but maybe should have put right at the top, was how to minimize taxes, right? And that is a very important and oftentimes the most important consideration when forming an entity. And oftentimes it does require the help of an accountant if there's already an accountant for one or more of the physicians, or sort of engaging a sort of an accountant on a new engagement kind of going forward. But that will oftentimes sort of drive how we do this. And I think I already touched upon the last one, right? How will equity holders come and go, right? So if we sort of think about trying to answer these questions in the context of the two significant choices, right? Either a professional limited liability company or a professional corporation. There are two variations with respect to the professional corporation scenario, which really give us three options, right, in terms of choice of entity, right? And the first one is to form an LLC, right? And that's sort of, if we're going to flip to the next slide. And if we sort of think about how this looks, ownership with respect to an LLC would be held by one or more what are commonly called members, who are basically sort of the equity holders. As I sort of already mentioned, all of those equity holders would have to be individuals, and they would have to be licensed to sort of practice with respect to whatever service the physician practice is sort of providing. Taxation with respect to limited liability companies, there's a lot of flexibility here, right? And if we think about taxation at sort of a broad level or sort of a high level, really the idea is, you've got sort of two levels. You've got the sort of entity level, and then you've got the equity holder level. And the idea is that between whatever taxes, income taxes, the entity pays and the equity holders pay, that the sort of sum of that should be as little as possible, right? And with a limited liability company, there is often a lot of flexibility because there is an ability to pick a couple of different ways to be taxed, where one of those is probably going to result in sort of the least amount of tax, right? And um, there are sort of a couple of scenarios. They can elect to just sort of be taxed as a limited liability company, which basically means that they're taxed as a partnership. That's kind of the default election, which means that there is no really income tax at the sort of entity level. And instead, all of the tax attributes and the sort of gains and losses and tax allocations flow through to the individual equity holders. And that is often attractive, not always, but often attractive. Another way to do it is to sort of elect to be taxed as a corporation, what's commonly referred to as a C corporation, where there's taxation at the corporation level and there's taxation at the individual level. And oftentimes, at least historically, that was never really attractive because it almost always resulted in more tax paid before the sort of ultimate amount received by the equity holders. That is not always the case now, particularly in light of some tax cuts from about 5 or 6 years ago. But that is sort of what requires the analysis, right? And then the other way is to elect to be taxed as what's called an S corporation, which avoids taxes at the entity level, but then results in taxes at the individual level, and is pretty similar to being taxed as a partnership, but not identical. So a limited liability company gives flexibility with respect to that. It gives limited liability with respect to the acts of individuals acting on behalf of the entity. Although when we're talking about the practice of professions, there is, in any event, or at least can be, personal liability for sort of negligent or sort of grossly negligent or sort of acts taken with misconduct. So it doesn't sort of, no scenario for physicians results in no liability, right? That'd be great, but that certainly is not the case. But limited liability company results in a pretty good reduction of liability overall. The management of a limited liability company is either vested in all of the equity holders or sort of one or more managers or a board of managers. So there's flexibility with respect to how the entity is managed from a legal perspective. There's also a lot of flexibility with respect to how cash is distributed from the entity to the members. And really, the equity holders are allowed to almost sort of dictate how those distributions go, and they don't have to be pro rata to all of the members or based on their equity ownership. So there's sort of a lot of flexibility there. And then there are sort of pretty standard formation and sort of governing documents. The main one after the sort of certificate of formation is the LLC sort of operating agreement, and that is going to talk about a lot of succession planning stuff and a lot of the agreement among members stuff that we're going to kind of get into later, right? So option one, in terms of forming a limited liability company, for a lot of different physicians that are sort of thinking about forming an entity, it is going to be an attractive option for sort of a lot of them, right? So that's sort of option one. Option two, which is on the next slide, is an S corporation. And if we just sort of run through this really quickly, I mean, the ownership of an S corporation has to be in individuals who are U.S. residents or essentially sort of permanent residents. So there's limitations on who can own, even the types of individuals that can own an S corporation. The taxation, I kind of already sort of alluded to how S corporations are taxed. Liability, it's sort of pretty similar in terms of being able to sort of protect individual practitioners to the maximum extent that they can be protected in New York, which is not totally. Management of any sort of corporation, whether it's an S corporation or a C corporation, essentially is in a board of directors that is appointed by the shareholders, and then that board of directors subsequently appoints officers. So it's more rigid in terms of what the sort of legal management structure looks like. Distributions are also much more rigid. They essentially have to be pro rata to all of the shareholders based on the number of shares that they hold. And then the formation and governing documents, again, are sort of relatively simple in terms of having a certificate of incorporation and bylaws that will talk about some of the relationship between shareholders. But then there is also oftentimes a separate agreement, a shareholders agreement, that gets into much more detail about the agreement or sort of the relationship between members, and also gets into a lot of the succession planning stuff, right? In terms of what happens if somebody wants to leave the practice and is required to sort of sell their shares. So that's sort of option number 2. Option number 3 is a C corporation. I put this one last because it is typically not the first choice and typically not the best choice. Although it can be in certain circumstances, and it also could be depending on where tax rates go in the future as well. So, but the ownership kind of similar to a C corporation, you essentially sort of have shareholders. They all have to be individuals, but they don't all, in a C corporation, they don't all have to be U.S. citizens or permanent residents. So a little bit more flexibility there. Taxation, I kind of already alluded to the idea that it is often the least desirable option from a taxation perspective because of the double taxation. Liability is really kind of very similar to the others. Management is also identical to the S corporation, where you have shareholders that then appoint a board of directors that then appoint officers, and that's how the sort of corporation is run, at least from sort of a legal perspective. Distributions are similar to an S corporation. It has to be pro rata, so not a lot of flexibility there. And the governing documents I've really kind of already kind of discussed in the context of S corporations. And so, you know, that was maybe a little bit dry because this is sort of, you know, legalese, for lack of a better way of putting it. But we do get into the heart of some very important things that physicians care about when we think about how much am I going to be taxed? What are my distributions going to look like vis-a-vis sort of other individuals? Who's going to run this thing? Who's going to be in charge? Who's going to be decision makers? And, you know, how's it going to look like when I want to get out of this thing, right? So, you know, really sort of important things that really should be thought about on the front end to sort of avoid a lot of heartache and litigation and fees and all sorts of stuff that people don't like on the back end, right? So that really is sort of the heart of sort of, you know, the sort of choice of entity sort of analysis. And so, you know, I think if we're going to kind of shift topics here, and this is probably a good time to sort of start to shift topics, I think the sort of next topic is sort of getting involved in the sort of corporate practice of medicine, and that whole sort of analysis and kind of a lot of different considerations with respect to that. And so in order to do that, I'm going to turn it over to my colleague, Jeff Gleason. Jeff?
Thanks, Nick. And just to kind of touch on some of the things that Nick was talking about, we lawyers tend to get a bad rap for being pessimistic or talking about the parade of horribles at the beginning of a relationship. People are coming together to form a business, and we talk about all the things that could happen at the end. It's like going into an engagement to be married and talking about divorce. It's uncomfortable, but especially when we're talking about entities and entity-based practices, it's important to think about these things beforehand so that you have the plans in place, because the last thing anybody wants to do is to end up in a business dispute with a partner who you had a really great relationship with at the beginning, and then you're just at loggerheads, and there's really not a mechanism built into your governing documents to actually affect that split up. And so you just kind of hang out in this period of limbo, negotiating, maybe lobbying missives back and forth, and it's really just a miserable way to practice. So kind of jumping back to again, another term that Nick brought up at the beginning of the presentation here, the corporate practice of medicine, and Nick touched on a lot of the topics here. You just kind of want to hammer in a little bit more. You're not going to find a statute in the New York State statutes that's called corporate practice of medicine. This is an amalgamation of a handful of other statutes. It's a really established doctrine, but it's kind of located in a bunch of different parts of the law. When we're talking about corporations, we have the New York State Business Corporation Law, Section 1507, which deals with professional services corporations. They can only issue shares to individuals who are authorized by law to practice in this state in that profession. Importantly here, as we get into some of the other aspects of transactions or private equity that we talk about later, this section of the law also talks about no shareholder in that corporation entering into any kind of agreement, a proxy, a voting trust agreement, which gives certain kinds of control over their shares to a person who is outside of the professional services corporation, and who's not licensed to practice that profession. So you kind of have to be wary of the kind of agreements that you enter into as a shareholder in a professional services corporation that may give another person rights to some of those shares, or certain rights to some of those shares. Similarly, we have the corresponding statute in the limited liability company law, Section 1207, goes into the same thing. Only people who are authorized to practice in that particular profession in this state can hold limited liability company interests. Interestingly, there's a tweak on this. The LLC law came about in the 80s, a little bit more modern, but they kind of create this provision for maybe you have a doctor who's coming out of med school, coming out of his residency, or you have somebody who's transferring states and the licensure process is still going. That person can become a member of a PLLC so long as the licensing takes effect 30 days after they become a member. Education law, Title 8, I threw that in here. This goes through a number of different kinds of practices. The practice of medicine, the practice of dentistry, ophthalmology, podiatry, pharmacy. They all have their own separate sections. In educational law, Title 8, this governs, again, the requirements for licensing in those professions, as well as the use of specific terms. We talked about, we're going to refer generally to medical professionals as physicians in this practice, but interestingly, there's a section of the educational law which speaks to the use of the term physician by licensed professionals. We also have, the various licensing statutes that are employed by, different parts of the government here. We have an embodiment of this. I noted the case here on the slide. United Calendar Manufacturing versus Wang. Very odd plaintiff to be involved in this, but this was a company that was doing business as Marcy Medical and Dental. Effectively, they were a referral organization. They were set up in Brooklyn. People could come in and they would kind of send out the work to actual licensed doctors or dentists. Dr. Huang was one of the doctors here. Eventually, he kind of took the patient list and was marketing his services as a solo practitioner of medicine outside of the context of this referral arrangement, where he had to give 30% of the fees received to the entity. I think if there's any doctors on this webinar, you'll know that's a big no-no. Eventually, it was the organization was trying to say he wrongly was soliciting these patients that were patients of Marcy Medical and Dental. The court said, no, you actually don't have any patients. You're not authorized to practice medicine in this state, so you can't have patients. You can't stop him from doing what he's doing. And oh, by the way, that agreement was completely null and void. He can't share these fees with you. So, that's kind of an overview of corporate practice of medicine. Why do we talk so much about that? Because we're also going to talk next about private equity. Again, if there are people who are involved in practices on this webinar, I think you or someone has been approached by an outside party to provide management services or buy the practice. There's a lot of terms that we can use for the kinds of transactions that practices can engage in, but we're going to talk generally about private equity and the market for the delivery of physician services. When we talk about the corporate practice of medicine, seems in contradiction to what we see out in the marketplace here. We see a lot of market activity, investment from private non-physicians, individuals, and firms. They're making the Wall Street Journal, they're making the Financial Times. There's a lot of money flowing into these kind of services, and that seems, at odds with what we just talked about, that these services can only be provided by doctors. So how is, KKR or some large investment firm getting involved in these practices? But they're quite obviously interested. I have this graph here. This is transactions in different disciplines of physician services from 2023. You'll see the giant spike and dental practices, a variety of other specialties here. And the deal counts, when you consider that in the context of a single year, that's a lot of deals. So, you have extreme interest from private equity firms, from private individuals. You have a lot of prevalence and penetration in the market. One of the things that you've seen in some physician organizations, the American Medical Association has talked about this. The concentration of some of these investments is being viewed as a problem by some in the medical community. You have private equity now owning more than 30% of the practices in almost a third of U.S. metropolitan areas. That's a lot of concentration where you have kind of these large non-clinical individuals, really making a lot of the decisions for the delivery of medical services. Obviously, that doesn't include the clinical decisions, but there's some folks who point out that one of the conflicts you create when you have private equity investment in medical practices is it's intended to alleviate some of the issues that physicians run into in running some of these businesses, taking out some of the overhead costs, taking out some of the administrative responsibilities, offloading those to other people who are not delivering clinical services, and allowing the physician to just deliver those clinical services. But there's a bottom line here, and so there's some folks, some organizations who are pointing to this as a problem and saying, well, even if you say that still the physician is delivering the clinical services, you have someone in the behind them or in their ear saying, oh, but we need to keep costs low. We need to, kind of deliver these clinical services in a different way that maximizes profit for the private equity firm. So, private equity's in the market. How did we get here? What does this mean for physician practices? So if we can advance to the next slide, I'll talk a little bit about some transaction structures that you've seen, because this is a avenue that a lot of physicians, a lot of medical professionals see as viable. They see it as a way to, maybe you're a retiring physician, you don't have someone in your office who's necessarily, set up to take over the practice. How do you monetize what you've spent your entire career creating? Or you have a group of physicians who are looking to, definitely looking to offload these administrative responsibilities and seeing, kind of the pressures that are facing your business on a financial aspect. You have lower, it's very difficult to negotiate reimbursement rates unless you're a very big provider, right? It's very difficult to attract new talent unless you can offer different kinds of financial incentives. It's, these are all kind of problems that practices face that you're trying to solve for, and maybe kind of this is your escape hatch. This is your parachute to say, if I can kind of monetize some of what I've done in my career to date and offload some of these administrative tasks to somebody else, that would be great. So how do we go about some of these transactions? One of them is this this friendly physician model, and you see this a lot of times when you have a smaller practice that is looking to quote unquote sell to a hospital or a hospital controlled entity, or an entity affiliated with an insurer. The way these are set up is that there's an entity, usually still a PC or a PLLC, and its sole owner is a practitioner in that specialty. Ultimately, there is an organization above them that is providing the administrative services still, but the assets of the practice are sold to this friendly physician PC, and there's a management services agreement in place to pull some of the profits and income out of that entity to the ultimate corporate entity that's sitting above this whole org chart, so to speak. The party on the other side of the management services agreement is that big entity, is that corporate entity, is that insurer affiliate. They are providing these services, but again, the sole owner there is someone who's friendly to them. They have the ability to replace that practitioner as the shareholder or member of the entity if kind of again things don't go so well, or that doctor leaves the employ of the ultimate corporate entity. So that's one structure. kind of one of the more common structures, especially for bigger deals, is this idea of management services organization. And one of the aspects of this kind of transaction that is appealing to a lot of physicians or medical providers is that you get to retain ownership of the entity. Again, we're not selling off kind of the practice to somebody else. The practice remains kind of sitting in the entity that is currently providing those services. The doctors, the physicians that are owners of that entity remain in place. And there's a management services organization created that sits kind of above that. Now, again, one of the attractive features of this kind of transaction is that frequently the owners of the actual entity delivering the clinical services take ownership in the management services organization as well. So you create an avenue of cash flow. You can sell non-clinical assets to this MSO. The MSO again provides all the back office services, pulls out its management fees for conducting those operational responsibilities, and the physicians are usually paid on an employment agreement. However, kind of when we talk about structuring that kind of transaction where your private equity firm is coming in as a management services organization, some issues can occur. We've had cases, in the New York Court of Appeals in Andre Carruthers versus Progressive Insurance Company, again set up through a management services organization, found that they had actually fraudulently incorporated the MSO and agreed to terms that were solely benefiting the MSO. So they kind of, they went a little bit too far. Now, if you're dealing with some private equity-backed management services organizations, they've obviously got the feel of this, right? Like, a lot of these are serial investors in the medical and healthcare fields, and so they've got their form of agreements. However, when you're talking about maybe some smaller practices, maybe some kind of smaller investment firms, that's something you need to be aware of. You can't give total control or too much control over to the MSO. Otherwise, it's seen again as the corporate practice of medicine. That MSO that has non-physician owners is actually practicing medicine. We can't have that. So, the private equity firms or, private equity investors, non-clinical investors may come in. They're setting up one of these transaction structures, and typically what you're going to see is they're looking for a 5 to 7 year investment cycle. They're looking to put that money in, set up this structure. They are looking to pull money out of the practice through these management fees. Again, typically the physicians receive a portion of that through their ownership of the MSO. But that doesn't mean that at the end of the 5 to 7 year investment cycle, you're looking at having to take back control of your practice in whatever state it may be, or you're looking to sell it off to a set of doctors. Typically in this area, we're seeing a lot of cycling through private equity sponsors in these deals. Heartland Dental, huge practice nationwide, has gone through 4 different private equity sponsors in 20 years. Recently, KKR did a big transaction where they are now the current owners of the Heartland Dental MSO. So to see private equity investment as kind of this relatively short term relative to your career of practicing medicine, it's short in terms of the number of years that private equity typically stays in these investments, but you're generally cycling through kind of a number of deals with different private equity sponsors. So much so that we're seeing in 2012 we had 75 deals nationwide in this space. 10 years later, we're talking about 484 deals and growing since then. So, going on to the next slide, we're going to talk a little bit about, for the people on this webinar who are practitioners, what does this look like? What kind of deal is this? Is this? And like I said, if you are a practitioner, you've probably gotten a call or know someone who's gotten a call from an investor. And what are those investors looking for? Let's say that you've decided that this is a good avenue for you. How do I go about thinking about this? Obviously private equity firms, again, they're looking for a return. They're looking for a profitable practice. They could be looking for hard non-clinical assets that they can lever with debt or something else, because again, they can take control of the non-clinical assets. But in terms of what you do, you are going to be looking at preparing yourself for the due diligence process, preparing yourself to be able to respond to requests and be able to tell these private investors, here's everything about my business. Here's why kind of my business is valuable, why you should invest in my business. And a lot of that has to do with how you maintain your records, how you go about contracting, how you think about running your practice day to day to be set up for the potential for one of these things. We're talking about a lot of your contracts. We need to make sure that we have active term on our contracts. There's a lot of people who, when they come in, private equity investors, I do a lot of private equity deals outside of the medical space too. And, we frequently encounter sellers who, have kind of contracts that are all over the place. They've expired. There is no renewal term on there. They're just kind of currently operating in those. Watching your contracts, watching, for active term on those contracts is important in order to maximize the value of your business if you're going to enter into one of these transactions. Kind of the flip side of that coin is you don't want to be locked into long-term contracts. A private equity firm coming in doesn't necessarily want, for instance, very low rates set for reimbursement for a period of 10 years. That's not where they want to be. Similarly, they don't want to have these long indemnification tails. When you're entering into a contracting arrangement, you don't want to expose the business to excessive indemnity so that, when a private equity investor comes looking through those contracts, they're saying, wait a minute, why are you saddling yourself with all this liability? We actually want you to keep that. And that reduces the value that you receive out of that transaction. Restrictive covenants are another thing. Obviously there's a lot of talk about non-competes in the market today. Our second webinar next in 2 weeks is going to talk about non-competes, but the business or its owners being bound by restrictive covenants to third parties is not great, or at least not great in the eyes of these investors. So how to prepare? Certainly if you're going to go down this route, you're probably going to want to think about engaging counsel, potentially engaging a broker very early. If you've been approached by an investor and you want to explore that deal, obviously you don't necessarily need your own broker. If you're going to market your practice because you see this as the avenue that you want to pursue, and there's nobody knocking down your door right now, you can engage in a broker to go out and market your practice to other investors, to other practices. There's no prohibition that you can't sell your practice to another professional corporation or PLLC. Kind of one of the things here, and this is going, maybe seen as a little self-serving from the lawyers who are giving this presentation, but we do find that sometimes there is this effort by clients to try to do too much too early in the process, and what that sets up for is a lengthier process because you kind of have to unwind maybe some of the things that weren't done properly in terms of a term sheet or a letter of intent, in terms of kind of producing all of the documents in due diligence or structuring the transaction in a way that will actually be compliant with law. Don't try to do too much yourself. There's certainly an effort to keep fees low on these transactions, and we understand that. But certainly involving your counsel, your accountants, everybody early on is going to make for a more efficient transaction process. So, that's a little bit overview of how the transactions work. I do want to touch a little bit on, some efforts that have been started and can even put into place with respect to the regulation of these kind of transactions. Again, when we first started talking about private equity's involvement, there are certain people, certain individuals, certain governmental entities, and medical organizations who are viewing this as not a good thing. And so they're lobbying for changes in law. If you go to the next slide, I want to talk about a couple of different things here. There's a new, relatively new, took effect August 1st, 2023 in New York. Article 45A of the Public Health Law now requires notification of the Department of Health of certain material transactions that happen in the healthcare space. They've defined what those material transactions are as mergers, acquisitions of one or more healthcare entities, which includes transfer of control of MSOs, affiliation agreements, partnerships, and joint ventures, kind of other different kinds of transactions you may enter into. There's now this notification requirement that at least 30 days prior to the closing of that transaction, the practice has to give notice to the Department of Health, and there's a 30-day waiting period for the before you can close on that transaction. During that period, the Department of Health may actually go out and provide public notice and seek comment from the public as to whether they think this transaction is a good idea. All that sounds really bad. However, there is also an exception in this law for what they've called de minimis transactions. This is seen as a big loophole that I think some critics of private equity transactions in the healthcare space would say private equity can drive a truck through. But the requirement, the exception carves out transactions that would not result in an increase in total gross in-state revenues of less than $25 million. Not a lot of meat on the bone there as to how that's going to be interpreted or how it will be measured. Like a lot of New York laws, I'm sure it'll be challenged over time, or there'll be an enforcement action, and then that'll be challenged. You'll see that a little bit in the third point as we get to here. But this is in place in New York. California and Indiana have implemented these laws. There is a law that's proposed currently in the Pennsylvania legislature. Don't really know if there's going to be any action on that before the end of their session, their 2024 session. Other states have seen efforts to implement these kind of laws stall out, including other states here in kind of the Northeast that you may have people in your organization, or if you're a larger practice, you may have locations in those states. There's also been federal proposals. Ed Markey and Senator Warren, both out of Massachusetts, coincidentally, have both proposed acts to require private equity-backed businesses to conduct more public reporting about the transactions they engage in. These laws also include potentially the obligation of private equity sponsors to be licensed in these states, and kind of unsure as to how that would how that would happen, whether that's kind of a separate class of license that private equity sponsor and MSO might have to obtain, because obviously they're not necessarily they're not physicians, and so kind of what does licensure mean in that context? Likely creating a new class of license, and kind of they propose criminal and civil penalties associated with actions that could be found to contribute to the death or injury of a patient in a clinical setting. Trying to push that liability out of the hands of just the doctors who are delivering those clinical services and up to the people who have the deep pockets, who've kind of put that money into the practice, but have at least according to these two senators, said, well, but we're not actually delivering those services, so if a patient dies or is injured, don't come after us. Lastly, you've had the FTC and the DOJ put out a joint request for information. This was focused on private equity's role in healthcare marketplace and healthcare organizations. They held public workshops. They then issued kind of a notice to Welsh, Carson, Anderson, and Stowe, a private equity firm, initiated an action targeting them for their activity in the healthcare space. The private equity firm Welsh Carson, they got that action dismissed. So then the FTC and DOJ came back and put out another second request for information focused on serial acquisitions and relative strategies, kind of taking a different tack at going after kind of some of these actors in the marketplace. Have not been successful to date. There's not a lot of substantive action that's taken place beyond kind of what we just talked about. And really, at the federal level, at least, we have an election year. And so, unless there is some wild swing into the control of government at the federal level, I doubt you're going to see a ton of movement on some of these proposals over the next 4 years at least. So, kind of let's set private equity a little bit aside and say, okay, so if a practice has not decided to go down this route, or they kind of want to take a different tack, but we still want to put in place some succession planning so that, when you, the doctor, retire, or, you're looking to hand the practice over to the next generation, what does that look like? And if you can jump to the next slide, and one of the things we can do is kind of borrow a page from private equity's playbook. These kind of methods of succession planning are things that I often put in partnership or operating agreements of private equity entities or private equity backed entities outside the medical space. When we're looking to incentivize owners. So one of them is, hey, let's create another class of equity. As kind of Nick pointed out, there's restrictions when you talk about S corporations. This kind of succession planning would not be available to professional corporations who have an S election. You can't have more than one class of equity. So to say, we're gonna put in place another class of equity with some minority rights, some minority voting rights, maybe different distribution rights, that's not available to PCs who have an S election. But in PLLCs, we can do this kind of separate class of equity. You can have maybe a board of managers who are charged with governance of the entity, except for maybe sale transactions, and that board of managers is kind of the old guard of the practice, or there's 3 named managers, and the 4th can be elected by kind of junior partners or associate physicians who are in your practice, who you've decided not necessarily to bring up to the level of equity partners, similar to kind of the more senior people, the people who may have started the entity. Another way you could do this is to create profits interest. Excuse me. Again, we typically see this in the context of a PLLC, and what a profits interest is. This is something that you can put in place even if you're considering a private equity transaction in your future, and you want to incentivize some of your younger physicians to stick around through that transaction. And the profits interest is this unfunded contractual right to payment upon the happening of some future event. They have usually a benchmark amount, and you say, hey, junior partner, associate doctor, you can participate in the upside of this future sale, but we're going to say, kind of the practice we've built till now is worth X. You get a portion of the sale prices over X, so that they're kind of it's a reflection of the time that they've spent in the practice, without kind of giving them full credit for the full value of the practice that they didn't necessarily help build from ground zero. So kind of that's those are 2 different ways you kind of can incentivize or provide equity or quasi equity to these other physicians in your practice, junior physicians, junior partners, kind of creating that other class. And then you employ these either in the context of a sale or in the context of succession. And so if we go to the next slide, we can talk about, okay, so then when there is no sale, what happens? Again, going back to the foundational documents that Nick talked about at the beginning, we want to have these concepts of succession built in so that kind of they're self-affecting when it comes time for one of these things to happen, the death or disability of one of your partners. It's tragic, but we need to figure out what happens then, right? What happens when one of the doctors wants to retire? What happens if one of those doctors wants to just, I'm sick of this place, I want to go work with another group of doctors. And then we have, events of involuntary dissociation, we'll call it. And a lot of these events are, the doctor doesn't necessarily want to leave, but you want to push them out. And having the triggers for those built into your foundational documents is important. This could be the failure to maintain privileges at the facilities, the hospitals and facilities that you practice, suspension or revocation of your license, conviction or plea to a crime, the vote of a certain percentage of members. Hey, we can effectively kick you out just by getting 2/3 of us to elect to do so, or the combination of any of the foregoing. And then, kind of what happens upon that. What do you do with that physician's interest in the company if any of these things happen? we need to think about what happens then. It could be that, the company buys back their interest, or the company has a right to buy back their interest first, or then it goes to, there's a secondary right to the other members, the other doctors, the other shareholders, to buy those interests in varying percentages. It could be a redistribution among several groups. But again, here we need to think about upfront, how does that actually work? Because when you're talking about purchasing an interest in a business like this, there's cash to be exchanged, and that could be all at once. That could be funded by life insurance in the event of the death of a partner. That could be, structured as you're only going to get a promissory note and we'll pay you over the next 5 years. And so, kind of all these things are great to think about up front and well in advance of any of these events happening, so that, again, when it happens, you're not just in a dispute with your partner or potentially former partner over how the repurchase of their interest is conducted. That's already built into what you're doing. So, kind of we talked a lot today about beginning and the end of a practice. We didn't talk a lot about the middle. When we talk in 2 weeks on the September 26th webinar, we'll get into a lot about that. We'll get into a lot about, kind of operational stuff. Obviously, in the third session of this webinar, we'll address that more. We'll talk about labor and employment issues. We'll talk about some of the other ways that your practice can maximize value and mitigate risk. And we hope that you'll join us at those as well. But in the meantime, if you have any questions, Nick and I are happy to answer them. Again, this is not a legal advice. Your circumstances are unique to you. And we hope that, we gave you a little bit of information here today that could have, be of some use for you in your practice. And we hope that, we can help you out in the future, whether it be in a sale or setting up a new practice, or however we can do that. We'd be happy to help. And Nick and I, our phone numbers, our email addresses are available on Bond's website. So thank you again, and we hope you'll join us in 2 weeks.